This episode of Real Law Review was made possible by Skillshare. Learn to think like a lawyer for free for 2 months by clicking the link in the description. Paul Manafort lied so much that the Mueller team is ripping up his plea agreement. This is very unusual, and this has huge implications for the entire Trump legal defense team. Let's think like a lawyer. On today's Real Law Review, I want to talk about all the implications that come as a result of Paul Manafort breaking the terms of his plea agreement with the Mueller legal team, including 1, why Manafort is going to jail for a long time, 2, how he has exposed all of his communications with President Trump and the rest of the Trump team, including those protected by attorney-client privilege, and 3, why even a pardon won't save Paul Manafort. This has huge implications for everyone, including the president. You may recall that Paul Manafort was indicted in 2 separate jurisdictions. He was a defendant in one particular criminal case in the Eastern District of Virginia, that's federal court, as well as the District of DC, which again is another federal district. The Eastern District of Virginia, because of its proximity to DC, handles a lot of very high-profile federal cases, and this is no exception to that. The Virginia case went to trial first. Paul Manafort was convicted on most of the crimes alleged in the Eastern District of Virginia case, and the jury hung on a few of those claims, meaning they weren't able to come to a unanimous decision on those particular claims. As a result of losing so many of the claims in the Virginia case, enough to put him away for the rest of his life, Manafort and his legal team decided to plead out in DC, meaning he took a plea agreement where he got a reduced sentence in exchange for him cooperating with the ongoing Mueller investigation. Not surprisingly, the plea agreement that Mueller and Manafort entered into requires that Manafort cooperate entirely, not only into the actual crimes that he was indicted and convicted of, but also for any investigations that Mueller wants his cooperation with and that Manafort might have some information that would help out. Manafort pleaded pursuant to an agreement that required his fully, truthfully, completely, and forthrightly cooperating with the government. According to the sentencing memo that the Mueller team just filed, the plea agreement provides that if the defendant, Manafort, fails to fulfill completely each and every one of his obligations under the plea agreement, or, quote, engages in any criminal activity prior to sentencing, the defendant, Manafort, will be in breach of the agreement. And of course, a breach relieves the government of any obligations under the plea agreement, including its agreement to a reduction of the sentencing guidelines for acceptance and responsibility, but leaves intact all of the obligations of the defendant as well as his guilty pleas. Which means that if Manafort violated the plea agreement, he is not entitled to any reduction of any of the crimes that he was convicted of, and in fact, he cannot withdraw his guilty plea as a result. No matter what, Manafort is going to be stuck with his admission of guilt with no reduction in sentence. In a status report that the Mueller team recently filed both in DC and Virginia, according to Mueller, after signing the plea agreement, Manafort committed federal crimes by lying to the Federal Bureau of Investigation and the Special Counsel's Office on a variety of subject matters, which constitute breaches of the agreement. The government will file a detailed sentencing submission to the probation department and the court in advance of the sentencing that sets forth the nature of the defendant's crimes and lies, including those after signing the plea agreement herein. This is a bombshell filing by the Mueller team. It is very rare for these kinds of plea agreements to blow up, and what the Mueller team has hinted at here is that Manafort not only just lied once and failed to communicate, but lied on a variety of different subjects. So what are the consequences of this plea agreement blowing up? Well, for one, the Mueller team won't be able to use Paul Manafort as a cooperating witness. They won't be able to rely on his testimony at trial. They won't get him to waive his Fifth Amendment rights against self-incrimination. And of course, Paul Manafort is going to jail for a very, very long time. The reason you enter into one of these plea agreements is to get a reduction in your sentence. You make it easier for the government to prove their case, you admit your guilt, and in exchange, the government gives you a letter saying that you should get a reduction in sentence. A judge has some some leeway in what sentence is actually handed down. There are federal guidelines, federal sentencing guidelines that provide a certain range, and the judge is allowed to choose from within that range. And the government states that because you cooperated with their investigation, you should get a reduction in your sentence at the low end of the sentencing guideline range. Of course, when you back out of a plea agreement like this, the government no longer needs to say nice things about you and no longer needs to argue that you should get a reduction in your sentence. And in fact, they will do exactly the opposite. Instead, the government will argue that because of your bad conduct, you should get an enhancement in your sentence. You should be at the high end of the range. Or if you engaged in new crimes, then you can be sentenced to additional time that was not reflected in your original guilty plea. So Paul Manafort is in a world of hurt. Manafort's breach of the plea agreement and lies to federal prosecutors may be related to a report coming out of the UK's Guardian newspaper, which reports that Paul Manafort met extensively with Julian Assange of WikiLeaks before the 2016 election. If that is proved to be true, that could have huge implications for the conspiracy and collusion investigation that's going on. On top of that, there is yet another bombshell that reports that while Manafort was acting as a cooperating witness with the Mueller team, both Manafort and his attorneys were passing secret information to President Trump and the other Trump campaign defendants. This is a huge bombshell. Generally speaking, if you talk to your lawyer, those communications are protected by attorney-client privilege. No surprise there. If you talk to a third party who is not your attorney, the general rule is there is no attorney-client privilege whatsoever. Those communications are not privileged and they are discoverable. However, when you have multiple defendants on one side, often they share what's called a common interest, which means that what's good for one defendant is also good for the other defendants. And as a result, it's very favorable to be able to share information among different defendants and their lawyers. And you wouldn't want to share that information if it breached attorney-client privilege and those communications were exposed. So the court recognizes what's called a common interest doctrine, which allows those defendants to communicate back and forth. To do that, you have to sign what's called a joint defense agreement, which basically just codifies that relationship and allows communications to go back and forth. However, the wrinkle comes when one of those defendants no longer shares a common interest with the other defendants. When one of those defendants enters into a plea agreement, that defendant's interests are no longer aligned with the other defendants. The other defendants presumably want to fight the case and want to be proven innocent, whereas the defendant who has pled guilty wants a reduction in sentence and wants to make the prosecution's case as easy as possible. So in that circumstance, those defendants are no longer in the same common interest. So what generally happens is that when one defendant pleads out, they remove themselves from the joint defense agreement so that their communications are not exposed and discoverable, and the other defendant's communications are no longer exposed and discoverable. But apparently, that did not happen here. Even after Manafort entered into his plea agreement, was a cooperating witness with the Mueller team, and had pled guilty to the crimes alleged in the District of Columbia case, he was still part of the joint defense agreement with the rest of the Trump team. That means that the communications that any of the Trump lawyers and Trump defendants had with Manafort or his attorneys while under the guise of this joint defense agreement are no longer protected. If those communications and that work product is no longer protected by the joint defense agreement and no longer protected by the attorney-client privilege, then they are discoverable. If I was one of Mueller's investigators, I would simply send a written request over to not only Paul Manafort's lawyers, but to all of the Trump defendant lawyers, demanding that they turn over any communications and any work product that was shared amongst themselves while Paul Manafort was a cooperating witness. Because Paul Manafort doesn't have the same interests as the rest of the defendants and potential defendants in this investigation, the common interest doctrine doesn't apply, and the joint defense agreement can't protect all of their communications and their work product. Not only does this have malpractice written all over it if the clients weren't apprised of the fact that they could be subject to these disclosures as a result of these secret communications, but on top of that, I don't think that Paul Manafort's lawyers are really going to be able to practice in federal court anymore because no prosecutor would ever trust them to keep the terms of a plea agreement secret. And if you can't negotiate with the government, then your value as a federal criminal defense lawyer is really going to plummet. So why would someone do this? Well, a lot of people are speculating that Paul Manafort is angling for a presidential pardon, and that may be true. There are two schools of thought here. The first is that Paul Manafort thinks he is the smartest guy in the room and he can beat the federal prosecutors. It's not uncommon for criminals to think that they are smarter than they are and smarter than the prosecutors who are going to put them in jail, especially when it comes to white-collar criminals like Paul Manafort, who are used to getting away with skirting the law and beating regulators. So it may be that Manafort just thinks he can get away with it. He lied his way into this situation and he can lie his way out of this situation. We'll see. The second school of thought on this is that Manafort is angling for a presidential pardon. If he works with Mueller, he can get a reduction in sentence, but the theory is that if he works with President Trump, who can pardon him, he can avoid jail altogether. That could be, but there are some problems with that, because remember, Manafort has been charged in both Virginia and DC, and there have been credible reports that Manafort is guilty of all kinds of crimes in New York as well. And the problem for Manafort is that a lot of the same conduct for which he has already pled guilty could give rise to state-level charges. Specifically, in the case of Virginia and New York, he could be convicted of tax fraud. And remember, a presidential pardon can only pardon federal crimes, which would still leave Manafort on the hook for any state law crimes. On top of that, the Mueller team is probably going to retry Manafort on all of the crimes for which the jury hung in Virginia, and they will argue for an enhancement of sentencing for the crimes that Manafort has already pled guilty. In the latest status report, the Mueller team has promised to lay out all of Manafort's lies and failures to cooperate in great detail. It's going to be fascinating to read that document. We don't have those details right now, but they're going to argue for a sentence enhancement. But the bottom line is that Paul Manafort is going to spend a long time in either federal or state prison. Of course, he could put that time to good use by learning a new skill like learning how to draw. He could take classes on how to draw comic book characters by Robert Marzullo on Skillshare. In fact, he could learn how to draw a whole comic about a guy named Super Paul who resides in the Mana Fortress. Skillshare is an online learning community that has over 20,000 classes on everything like design, technology, business, you name it. And the first 500 Legal Eagles to click on the link below will get 2 free months of Skillshare just by clicking the link. The free premium membership gives you unlimited access to must-know topics so you can improve your skills and learn new things, just like Paul Manafort will when he goes to prison. So click on the link and start learning today. And until next time, I'll see you in court. Instead of packing up his bags when the Supreme Court said the president is immune from almost everything, Jack Smith said screw it, re-indicted the former president, and included a whole bunch of new evidence for the former president's crimes. When life gives you lemons, you make lemonade, even if it's criminal lemonade. I don't know, the metaphor breaks down. So Jack Smith is trying to make lemonade with a 165-page motion laying out all the ways that Donald Trump tried to overturn the 2020 election results, and it includes a whole bunch of new bombshells. You might recall that Smith was forced into this position by the Supreme Court, which ruled that Trump was almost certainly immune from criminal prosecutions for trying to overthrow the government, as long as he was doing president-like things while breaking the law. Justice John Roberts told Smith that he could rebut the presumption that Trump was above the law, but didn't tell him how to do it. So here we are now with hard mode activated. Smith first filed a superseding indictment removing things that were clearly off limits, now, according to the Supreme Court for the first time, like Trump weaponizing the Department of Justice with the help of power-mad environmental lawyer Jeffrey Clark. Smith's new brief is a granular analysis of everything that Trump did to cling to power. The motion divides Trump's acts into things that he did in the service of his campaign, which are presumably fair game, versus things that he did as president, which are presumably strictly off limits. So in response to the Supreme Court in U.S. versus Trump, Jack Smith had to go back and basically do a mini-trial to make sure that the claims that he alleged would pass constitutional muster. And while the Supreme Court didn't make it clear what exactly needed to happen, at a bare minimum we know that Smith needed to make a prima facie case on both the facts and the law before proceeding. So Smith apparently put his best evidence and legal arguments forward. Meanwhile, Smith's motion was treated as breaking news by even Fox. Anchor Neil Cavuto reported,
in this newly unsealed court paper, we're learning that former President Trump resorted to crimes in a bid to cling to power after the 2020 election.
So let's break down all the new stuff that we learned about Trump's 2020 coup attempt. Now, Donald Trump has been on the national political scene for over 9 years now, and during this time, Congress and the courts have treated his attempts to interfere with elections as a hot potato that they have to toss back and forth. And this started with the Mueller report's finding that Trump may have committed 10 acts of obstruction of justice, but Mueller concluded that Congress was responsible for holding him accountable. Congress said no thanks. Then in 2020, Trump lost to Joe Biden. Months of drama followed, ending with Trump supporters rioting at the Capitol on the day that Congress was supposed to certify the result. Now, the principle of presidential immunity protects the president from certain civil acts and some criminal prosecutions during their time in office. In Trump versus United States, the Supreme Court ruled that presidents enjoy a strong presumption of immunity for any official act undertaken while president. And the ruling prevents prosecutors from using official acts as evidence in a criminal case, even if the presidential acts are related to private conduct. To overcome that presidential immunity, the prosecution has to prove that there are, quote, no dangers of intrusion on the authority and functions of the executive branch, with no other factors to consider. The court also gave the president absolute immunity for certain core presidential functions, and Justice Roberts interpreted core functions so broadly that they might even encompass a president ordering a Department of Justice to conduct a sham investigation into allegations of fraud the president knows are fake. District Court Judge Tanya Chutkan in D.C. must now determine whether Trump is immune for the actions he took to overturn the 2020 election. And Judge Chutkan granted Smith's motion to file a motion on the immunity determination and allowed Smith to file a redacted version on the public docket. She also allowed him to file a much longer brief than would normally be allowed for motion practice. But in that brief, Smith argues that the court should draw a line between Trump's actions as president and his actions as a private candidate for president. Quote, the defendant asserts that he is immune from prosecution for his criminal scheme to overturn the 2020 presidential election because, he claims, it entailed official conduct. Not so. Although the defendant was the incumbent president during the charged conspiracies, his scheme was fundamentally a private one. Working with a team of private co-conspirators, the defendant acted as a candidate when he pursued multiple criminal means to disrupt, through fraud and deceit, the government function by which votes are collected and counted, a function in which the defendant, as president, had no official role. This brief is Smith's attempt to show Judge Chutkan in the courts of appeal that Trump is not immune. And as I said, the Supreme Court didn't give a lot of guidance on how to apply its decision, and said nothing about how the presumption of immunity could be rebutted. And faced with this problem, Smith relies heavily on the D.C. Circuit Court decision in Trump versus Blazingame, a civil suit about whether Trump was entitled to absolute presidential immunity for allegedly inciting the January 6th riot. In that case, the Blazingame court held that the president is not entitled to civil immunity when he's acting as an office seeker rather than an office holder. The court said, quote, when a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic about who will occupy it next, and campaigning to gain the office is not an official act of the office. So when a sitting president running for a second term attends a private fundraiser for his re-election effort, hires or fires his campaign staff, cuts a political ad supporting his candidacy, or speaks at a campaign rally funded and organized by his re-election campaign committee, he is not carrying out the official duties of the presidency. He's acting as an office seeker, not an office holder. No less than are the persons running against him when they take precisely the same actions in their competing campaigns to attain precisely the same office. And Smith embraces this rationale. Quote, consistent with the D.C. Circuit's opinion in Blazingame, the Supreme Court suggested that a president who speaks as a candidate for office or party leader, as the defendant did here, does not act in his official presidential capacity. As the D.C. Circuit explained, a president acting as a candidate for re-election is, to that extent, not carrying out an official responsibility. Now, obviously, if you tried to overturn a democratic election, you'd want a good lawyer, not any of the scummy and villainous lawyers that Trump actually had. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery and at least find out what your options are going forward. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below. Now, turning to the new alleged facts and evidence that were presented, according to the brief, Mike Pence spent weeks trying to convince his boss to stop trying to deny that he lost. On November 7th, Pence started with flattery, telling Trump he, quote, took a dying political party and gave it a new lease on life. Pence next attended 2 meetings where lawyers explained that Trump would probably lose all of the pending lawsuits. On November 12th, Pence had a private lunch with Trump where, quote, Pence reiterated a face-saving option for the defendant. Don't concede, but realize the process is over. They had another private lunch on November 12th where Pence attempted to get Trump to give up but just run again in 2024. And as December wore on, Pence tried to usher Trump through the stages of grief, telling him, quote, not to look at the election as a loss, just an intermission. In response, Trump allegedly pressured Pence to violate his oath of office by rejecting slates of electors from swing states Biden won. And during the riot, Trump was at best indifferent to Pence's physical safety. When rioters breached the Capitol building, Trump sent an infamous tweet at 2:24 p.m., quote, Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones, which they were asked to previously certify. USA demands the truth. And when rioters got to within 40 feet of Pence, the Secret Service had to evacuate him. But when Trump's team told him that Pence was in harm's way, he allegedly responded, "So what?" Yeah. So the government's filing indicates that they plan to introduce evidence from Trump's cell phone if they go to trial. And according to the government, Trump was all alone in the dining room when he sent that tweet, and he was acting as a candidate, not the president. Quote, the content of the 2:24 p.m. tweet was not a message sent to address a matter of public concern and ease unrest. It was the message of an angry candidate upon the realization he would lose power. Trump's advisors urged him to call off his dogs, but Trump waited 14 minutes to tweet, and when he did, he said, "Please support our Capitol Police and law enforcement. They are truly on the side of our country. Stay peaceful." But his aides didn't think this was good enough since the riot was still going on, so Trump followed that up with a video message at 4:17 where he said he loved the rioters. Then at 6:01, Trump tweeted, "Go home with love and in peace. Remember this day forever."
So go home. We love you. You're very special.
But under the court's decision in Trump versus U.S., these were arguably official acts, so Smith had to argue around it. Quote, the defendant at least has an argument, though he issued the 2:38 p.m. and 3:13 p.m. tweets only after being harangued by his staff while he adamantly refused to do anything at all, that he was addressing a matter of public safety as president, the riot at the Capitol. Likewise, in the 4:17 p.m. message, the defendant, while still focused on his election loss, asked rioters to evacuate the breached Capitol and foreshadowed the sentiment in his 6:01 p.m. tweet, when he said to, quote, "Go home with love and in peace." By contrast, in the 2:24 p.m. tweet, the defendant focused solely on the vice president's role in the certification of the presidential election results, a matter of intense personal concern to the defendant as a candidate for office. Even assuming that the topic constituted a matter of public concern, the defendant's 2:24 p.m. tweet reflected speech made in an unofficial private capacity as an office seeker, not an official capacity as an office holder. That's a lot of processing about the 2:24 p.m. tweet, but this is what the prosecution has been reduced to by the Roberts Court. Smith literally has to spend 6 pages explaining why he should be allowed to use a single tweet as evidence of a crime. And he notes that both the Hatch Act and the Supreme Court's decision in Lindeke versus Freed, which confirms that a public official's personal social media account can be used for both personal and public business. Now, Trump argues that his conversations with and about Pence are official acts. And Trump responds that discussions between Pence and Trump about overturning the election results can't be official acts because neither office plays a role in determining the outcome of the election. Quote, the government is aware of no contrary evidence, including of any president other than the defendant, seeking to influence his vice president in the discharge of his duties as president of the Senate in presiding over the joint session. The absence of any such historical tradition is reinforced by the fact that in 22 of the 59 certification proceedings, the vice president has not presided at all. When it comes to the certification proceedings specifically, not only has the president been deliberately excluded from the process, but the vice president's role as president of the Senate is highly circumscribed and ministerial in nature. Smith also provides new evidence that Trump's cronies wanted to incite a riot. Quote, in the immediate post-election period, while the defendant claimed fraud without proof, his private operatives sought to create chaos rather than seek clarity at polling places where states were continuing to tabulate votes. For example, on November 4th, when votes were being counted at a tabulation center in Detroit, someone pointed out that, quote, we think a batch of votes heavily in Biden's favor is right. A person identified as P5, who is a campaign employee, agent, and co-conspirator, said, quote, find me a reason it isn't. Then another person brought up the, quote, Brooks Brothers riot, a political protest that took place on November 22nd, 2000, at the Miami-Dade County Canvassing Board office. The protesters were a group of Republican operatives who were demanding an end to the recount process in Bush versus Gore.
Stop the count! Stop the fraud! Stop the count! Stop the fraud! Stop the count! Stop the fraud!
P5 replied, make them riot and do it, with 3 exclamation points, which suggests the Trump campaign was eager to interrupt the vote counting by any means necessary, including violence. And Smith also argues that under the Hatch Act, White House staff can wear 2 hats as campaign staff and executive branch authorities, but they can't wear them at the same time. Quote, simply because a staffer holds a title in the executive branch and interacts with the president does not mean that the interaction is necessarily official. For example, P15, a staffer, witnessed a conversation between Trump, Melania, Ivanka, and Jared Kushner aboard Marine One where Trump unprompted said, quote, it doesn't matter if you won or lost the election, you still have to fight like hell. Smith argues, quote, this statement is plainly private. It was exclusively about the election and the defendant's determination as a candidate to remain in power whether he won or lost. If the judge allows P15 to testify, he will say that he did not participate in the conversation, he was just an observer. And I look forward to hearing what the Supreme Court justices say about this interaction. We should expect their decision sometime in 2031. And when Trump was trying to overturn Biden's victory, he threatened to fire the acting attorney general because he would not confirm Trump's election fraud claims. But Justice John Roberts wrote that this implicated the, quote, investigative and prosecutorial decision-making authority that is the special providence of the executive branch. Roberts concluded that a president's official duties included communicating with the DOJ to ensure there isn't election fraud. And this is probably one of the worst parts of the court's decision because it seemed to confirm Richard Nixon's belief that when the president does it, it's not illegal. But what about all the times that Trump communicated with staff officials about overturning the results? Well, Smith argues that unlike his conversations with the DOJ, these can't be official acts because the president doesn't have a role to play in the ascertainment of electors. Quote, as president, the defendant had no official responsibilities related to the state's administration of the election or the appointment of their electors, and instead contacted state officials in his capacity as a candidate. Tellingly, the defendant contacted only state officials who were in his political party and were his political supporters, and only in states that he had lost. Smith argues that if Trump was really concerned about fraud, he would have called up Democrats and governors in states he won or reached out to candidates who lost their own races. But Trump didn't care about any race other than his own. Moreover, the motion includes reams of evidence suggesting that Trump knew his fraud claims were false. Quote, at trial, the government will elicit testimony from election officials from the targeted states to establish the objective falsity and often impossibility of the defendant's fraud claims. Notably, although these election officials would have been the best sources of information to determine whether there was any merit to specific allegations of election fraud in their states, the defendant has never contacted any of them to ask. History confirms that presidents have never understood their wide-ranging duties to encompass any direct role in the function of collecting, counting, and certifying the result of a presidential election. Now, we also know that Trump had a scheme to overturn the election by using fake electors. This also is illegal. But the Trump versus U.S. decision means that Smith has to explain why the president, unlike his co-conspirators, isn't above the law. And one way Smith does this is by arguing that the president kept some White House personnel away from those conversations. For example, he included his private lawyers to pressure Pence. That's arguably outside the scope of any executive function. Moreover, Trump excluded the White House counsel from a meeting about the fake electors and the role that Pence was supposed to play in the scheme. Smith says, quote, it is hard to imagine stronger evidence that conduct is private than when the president excludes his White House counsel and only wishes to have his private counsel present. And Trump's attempt to change the election results ran mostly through Rudy Giuliani and his team of private lawyers. One senior Trump campaign advisor was exasperated with the obviously wrong legal claims. This person claimed that Trump's wacko legal team was the Star Wars bar after the cantina scene in Star Wars. Quote, when our research and legal team can't back up any of their claims made by our elite force strike team, you can see why we're 0-32 on our cases. All obviously hustle to help on all fronts, but it's tough to own all of this when it's just conspiracy shit beamed down from the mothership.
You will never find a more wretched hive of scum and villainy.
The Star Wars bar included legal luminaries like Rudy Giuliani, Jenna Ellis, and Sidney Powell. And Trump theoretically knew that his legal claims were bogus. On November 20th, during a conference call with the Kraken herself, Trump muted her, called her crazy, and made a reference to Star Trek when describing her allegations. Now, unbelievably, Jack Smith doesn't tell us what this Star Trek reference was. If only we knew. Which character is Donald Trump? Who is Sidney Powell? And just how crazy is Powell that you have to make a metaphor based on extraterrestrial fiction? But let us know what you think the reference is down in the comments. Now, generally, Smith did a pretty good job in a tough circumstance. And there is obviously compelling evidence that the president tried to remain in power by creating fake voters and fraud claims. And it's an indictment of our system that we couldn't put this away before Trump was a candidate in the 2024 election. But as for this DC case, it's safe to assume that Judge Chutkan will rule that at least some of the evidence can be properly admitted at trial. But Trump will definitely appeal her decision to the DC Circuit, and he will appeal that decision to the Supreme Court. And the ultimate outcome of this case will largely depend on how much the Supreme Court will embrace the DC Circuit's decision in Blazingame in the criminal context. Will the court agree that campaigning to gain the presidency is not an official act of the office? Or will the Supreme Court just go full Nixon and say, if the president did it, and even if it's campaigning, it still counts as a presidential official act? Now, obviously, people on both sides of the aisle are up in arms about all of these cases, and it's also reflected in news reporting as well. But what's interesting is that Jack Smith's superseding indictment of Donald Trump has been covered extensively by over 400 news outlets. Now, 40% of the reporting is coming from the left, and only 24% is coming from the right. But if you compare the headlines, you'll start to see some interesting frames emerge. On the left, you had one news outlet framing the indictment by arguing that the Supreme Court will unjustly give Trump immunity. And on the right, you might see the opinion of Republican Representative Rick Scott, who called the superseding indictment complete election interference. And depending on which article you saw first, your view of the story would be completely different. If you read left-leaning news sources, you might feel grateful that Jack Smith is on the ball, fighting for justice against Trump and the partisan Supreme Court. And if you lean right, you might think this whole deal is overblown and that Trump had a right to question the outcome of the election, as with this headline from the noted objective legal news source, The Federalist. Now, all this is possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Ground News is my absolute favorite way to read the news. Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. And one of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum, like the superseding indictment. It helps explain why we often talk past each other and why some people seem hyper-focused on what seems like complete nonsense, often because some random blog post went viral among certain people. But either way, Ground News is fantastic. And as a legal eaglet, you can save 40% off of the Ground News Vantage subscription by clicking on the link that's on screen right now or down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link that's on screen right now or down below to get a 40% discount off of the Ground News Vantage subscription and get all the Ground News tools. And after that, click on this link over here for more LegalEagle, or I'll see you in court. So now they are deporting American citizen toddlers with cancer. I don't know which of those 3 things is the most horrific. And I'm not kidding, there are reports that the Trump administration has now deported at least 3 children ages 2, 4, and 7 who are US citizens, and at least one of whom was receiving cancer treatment. So by now you know they're trying to rendition immigrants off to a foreign gulag in El Salvador without a hearing or a trial. But it looks like they are now trying to send American citizens away next. And I have to admit, before I looked into it, I didn't know what, if anything, could prevent that. I mean, we have private prisons in the US, so what, if anything, would prevent the US government from simply offshoring all of our prisons to foreign nations and sending citizens away? Well, thankfully, it turns out a lot. Now, in recent weeks, we've watched the Trump administration whisk people off for indefinite stays in Salvadoran torture prisons with absolutely no due process rights, no hearings, no jury findings, and not even notice of any criminal or immigration violations. And a lot of people have looked at that situation, shrugged, and said they're not worried because the people that the Trump administration is sending off to torture prison are undocumented immigrants, not citizens, and nothing like that could ever happen to a U.S. citizen.
What about Americans he would do? And you talk about me listening to the senator literally
Congressman,
to
my
represent
question is
him.
about
It seems to
US
me that these
citizens.
Democrats are representing.
But the thing about abusive government regimes is that they usually start off by persecuting the marginalized people first. They test out some rights violations on immigrants and minorities, and they rarely stop there. And you can tell your misinformed uncle who got his law degree from Twitter University that the US Constitution applies to immigrants as well. And they too are entitled to due process. But eventually abusive regimes move on to persecuting everyone. And following up on that playbook, Trump has now personally indicated that he wants to send, quote, homegrown criminals to Salvadoran torture prisons as well.
We also have homegrown criminals that push people into subways, that hit elderly ladies on the back of the head with a baseball bat when they're not looking, that are absolute monsters. I'd like to include them in the group of people to get them out of the country.
President Trump's press secretary has confirmed this aspiration, and he's asked his Attorney General Pam Bondi to study this question as well.
We're studying the laws right now. Pam is studying. If we can do that, that's good.
Well, Pam, you can take the weekend off because I've done your homework for you. And I've concluded that this idea violates a couple of constitutional provisions and a whole bunch of laws. Not that I think that will stop you. But first things first, can the Trump administration send Americans away without holding criminal trials? Definitely not. Now, we've already spent several videos going in depth about the Trump administration's non-legal actions towards immigrants. The short version is that ICE has been picking people up off the streets and off campuses and violating their constitutional rights by whisking them away to detention centers, often without even informing them about the justification for their detention, nor charging them with any crime. In retaliation for his First Amendment protected speech, Khalil Mahmood, a Columbia University protester on a lawful student visa, was picked up by plainclothes police officers in his campus housing apartment building and then spirited away to detention centers in New York, then New Jersey, and then finally Louisiana, where the Trump administration did their best to keep him from being able to reach his attorney or his family. Other immigrants like Hilmar Abrego Garcia have been picked up, shuffled around detention centers, and then put on planes, and then sent for indefinite prison terms in an El Salvadorian gulag without ever receiving a hearing or having a chance to get the assistance of an attorney, a violation of both their Fifth Amendment due process rights and their rights under the Immigration and Nationality Act. And even more disturbingly, we learned last week that the Trump administration has deported 3 children who were U.S. citizens. The youngest child, who was only 2 years old and was born in New Orleans, was picked up with her mother when her mother went to her scheduled regular check-in with immigration officials. Despite the fact that the mother showed up dutifully to that appointment, ICE detained her, then deported both her and her daughter to Honduras. The Trump administration claimed that the child's mother wanted the child to be sent away with her, but there was never a hearing to establish this or time for the mother to adequately discuss the issue with the child's father, who says that he did not want the child to be sent to Honduras with her mother. And on April 25th, a judge in the child's case issued a blistering rebuke against the Trump administration, proclaiming, quote, "Of course it is illegal and unconstitutional to detain for deportation or recommend deportation of a U.S. citizen." Judge Terry Dowdy, United States District Court judge for the Western District of Louisiana, said it appeared as though the government had just, quote, "deported a U.S. citizen with no meaningful process." On top of that, 2 more children, 4 and 7 years old, were also deported with their pregnant mother after she was picked up at a regularly scheduled immigration check-in. Both children are citizens, and one of them has cancer and was undergoing treatment. The mother's attorney repeatedly tried to reach her after she was picked up, but ICE blocked her access and put the family on a plane to Honduras within 24 hours of detaining them. Now, it is possible, as the Trump administration suggests, that the parents who are removable may elect to take their minor children with them, but it could create a weird situation where the child could return to the United States whenever they wanted, but the parents could not. But all the more reason to make sure that the parents get the regular process, which looked like it didn't happen in these cases. And we'll talk about that more. And as we've discussed before, in the immigration context, immigrants still retain due process rights in the criminal justice system, but in an immigration context, they also are entitled to a parallel specialized system created by the Immigration and Nationality Act, which governs the immigration system and generally requires notice of the government's intended action, opportunity for the immigrant to rebut the evidence, and an opportunity to be represented by counsel. Though the Trump administration has been treating these rights as optional and has been getting schooled by the courts for skirting the usual processes. But it's clear that the administration intends to keep testing the limits and try and get away with whatever it can get away with. Now, there is good reason to believe that the Trump administration has infringed on the constitutional rights of the immigrant detainees. But the protections for citizens are likely even stronger. American citizens are entitled to due process under both the 5th and 14th Amendment. These amendments cover the same rights, but the 5th Amendment due process protections apply to actions by the federal government, and the 14th Amendment due process protections apply to actions by state governments. Now, the 5th Amendment requires that no person should be, quote, "deprived of life, liberty, or property without due process of law." The 14th Amendment language mirrors this, stating that, quote, "nor shall any state deprive any person of life, liberty, or property without due process of law." Now, due process includes 2 buckets of things: procedural due process rights and substantive due process rights. Substantive due process focuses on protecting from government infringement on a broad set of fundamental rights, such as the right to marry, the right to privacy, to have a job. Though, full disclosure, substantive due process rights have been curtailed quite a bit by this particular Supreme Court. But procedural due process focuses on specific procedures that the government must follow before taking away someone's liberty or property. And procedural due process is the stuff of Law and Order episodes, the Miranda warnings, trial, evidentiary rules, and a jury system that we're all familiar with. But due process rights can be triggered by a wide variety of life, liberty, and property interests, not just by imprisonment as part of a criminal justice matter. Due process rights apply when the government terminates a benefit or issues a fine or hands down a monetary civil judgment against a person. And there are different standards regarding what constitutes due process in civil and criminal matters. Now, for the purposes of this video, I'm going to focus on the procedural due process rights in criminal matters, because the criminal justice system seems to be what Trump is talking about when he's talking about homegrowns. Now, at a minimum, in criminal matters, people are entitled to notice of the charges against them, an opportunity to be heard, and an impartial tribunal. A party must generally be given an opportunity not only to present evidence, but also know the claims of the opposing party and to respond to them. In the criminal context, due process also typically requires other procedural protections, such as an opportunity for confrontation and cross-examination of witnesses, discovery, and the opportunity to be represented by counsel. Which is pretty much exactly the exact opposite of what has been happening so far with Trump's deportation and rendition cases. Trump has publicly accused the detainees of being gang members, terrorists, or human traffickers, But many of the people who are being sent to the CICOT torture prison in El Salvador were never given an immigration hearing, let alone a full criminal trial with any of the above guaranteed rights. And by imprisoning people, citizens or immigrants, with no due process, the administration is violating their Fifth Amendment rights. Now, sending an American citizen off to a Salvadoran torture prison would also likely be a violation of the Non-Detention Act. The Non-Detention Act was enacted to repeal a McCarthy-era statute that allowed the government to detain suspected subversives without due process. The Non-Detention Act requires an act of Congress for the executive to be able to detain a U.S. citizen without process. It states that, quote, "No citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress." But it seems like the Trump administration thinks it's found a way to get around the legal due process requirements anyway. It just has to remove someone from the United States fast enough and all their rights disappear like magic, because if you whisk someone away fast enough, the judicial system can't catch up. Now, the Trump administration isn't the first presidential administration to try this one weird trick. After the September 11th attacks, the George W. Bush administration set up offshore sites where accused terrorists were held. Some detainees were held as military combatants in CIA black sites in Europe and the Middle East. Others were held in Guantanamo Bay, Cuba. And typically, if someone, citizen or non-citizen, is being improperly detained by the government, the remedy for that is a habeas petition, which is a motion that asks the court to consider the legality of a person's detention. Jurisdiction for this typically lies in the place where the person is being held. Nonetheless, despite the fact that the detainees were being housed offshore, U.S. courts, including the Supreme Court, found that they had habeas corpus rights in U.S. courts. For example, in Rasool versus Bush, a group of Australian and Kuwaiti citizens who were being detained in Guantanamo challenged their detention with a habeas petition. The government argued that the detainees weren't actually within U.S. government control, so U.S. courts did not have jurisdiction. Now, the Bush administration pointed to the fact that the Guantanamo Bay land is not actually owned by the United States, it's leased from Cuba. So therefore, the Bush administration argued Cuba retained ultimate sovereignty over the land, so U.S. courts had no jurisdiction and couldn't hear habeas petitions from the prisoners being held there. But the U.S. Supreme Court disagreed, holding in a 6-3 decision that the degree of control exercised by the United States over the Guantanamo Bay base was sufficient to trigger the application of habeas corpus rights. The court also held that the right to habeas corpus is not dependent on citizenship status. And a related case, Hamdi versus Rumsfeld, which discussed the Non-Detention Act, actually did involve a U.S. citizen. Yasir Hamdi was born in Louisiana and was captured in Afghanistan a few months after the September 11, 2001 attacks. The Bush administration first detained him in Guantanamo, then, after realizing he was a citizen, transferred him to a naval brig in Virginia, and later another naval brig in South Carolina. Hamdi's father filed suit on his behalf, arguing that his indefinite detention without trial was a violation of the Non-Detention Act, which again states that no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. The Bush administration countered that the authorization for use of military force, the AUMF, passed after the September 11th attacks, met the Non-Detention Act standard for an act of Congress. And the Supreme Court agreed with the administration that the AUMF qualified as an act of Congress that satisfied the Non-Detention Act, but the court made it clear that Hamdi must be afforded at least some due process rights, and those rights could be somewhat relaxed given the ongoing war in Afghanistan, but even in the context of extreme wartime exigencies, detainees still had at least to be given some amount of due process, specifically the notice of the factual basis for their classification and a fair opportunity to rebut the government's factual assertions before a neutral decision maker. Writing for the court, Justice O'Connor stated, quote, "It is during our most challenging and uncertain moments that our nation's commitment to due process is most severely tested, and it is in those times that we must preserve our commitment at home to the principles for which we fight abroad." So even in the wartime context, which is relevant here because President Trump is claiming this is a foreign invasion, the government can't typically just suspend all due process and detain people, even terrorists, indefinitely without some kind of trial. But what if, in an uncharacteristic show of patience and restraint, the Trump administration actually allows U.S. citizens to be convicted in a criminal trial with due process rights first? Then can it send people off to stay in a Salvadoran torture prison? Now, if you're not the U.S. government and you're kidnapping people and sending them to a foreign country, you're going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've got in a car crash, suffered a data breach, especially if you got a data breach letter saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can maximize your recovery. By the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Click below. Well, actually, this is a practice that was so common in the British sphere of influence that it actually has a name. It's called exile. And historically, exile, sometimes also called transport, was used as a tool to punish convicted criminals. In fact, Great Britain sent an estimated 50 to 120,000 criminals, political prisoners, and prisoners of war to the American colonies in the 1600s and 1700s. For obvious reasons, subjects of the crown weren't happy with this punishment. In fact, one of the grievances the founding fathers listed in the Declaration of Independence was the fact that King George III had, quote, transported us beyond seas to be tried for pretended offenses. Now, there are many reasons why transport was a particularly cruel punishment. It separated criminals from their families and communities so they could not even have visits. That separation also made it easier for their captors to engage in abusive practices. And though the sentences were often finite, they ended up effectively being life sentences because prisoners could often not afford to pay for a ticket back to their home once the prison terms had ended. But here in the United States, we don't send people abroad to serve prison sentences. At least, not yet. But the government has sent people to prisons that are still within the United States but are unreasonably far from home. In an effort to remedy that and other flaws in the criminal justice system, Congress passed the First Step Act, a bill that aimed to reduce recidivism, allow for inmates to earn sentence reductions, and improve prison conditions. Now, that bill was signed into law in 2018 by President Trump in his first term. And one of the provisions of the First Step Act specifically requires the Bureau of Prisons to house inmates in facilities that are as close to home as possible, preferably within 500 miles. So sending someone to a foreign country, any foreign country, would likely be a violation of the First Step Act, unless the Trump administration can make a strong case for why it can override the requirements in that legislation. But even if the administration can claim that there are security reasons or some other justification for why convicted U.S. citizens cannot be kept close to home in keeping with the First Step Act, there are still serious constitutional problems with sending U.S. criminals to be housed in other countries. Even the Bush administration, which took a famously dim view of civil liberties, knew this, which is why when it realized that Hamdi was a U.S. citizen, it moved him out of Guantanamo and onto a brig in Virginia and then South Carolina. In a 2017 case called Doe versus Mattis, which I'll discuss more in a minute, the D.C. Circuit Court found that, quote, a fundamental attribute of United States citizenship is the right to remain in this country and to return after leaving. That right is implicated when the government seeks to forcibly transfer an American citizen from the United States to a foreign country. In Doe, the D.C. Circuit was considering whether a U.S. citizen could be transferred to a third-party country or potentially be imprisoned there. The court ruled that forcible transfer to another country's custody would violate the fundamental attribute of citizenship. Customs and Border Protection's own website also cites the right to live in the United States as an inherent right of citizenship. CBP's website says, quote, a U.S. citizen's right to remain in the United States cannot be taken away. Now, many experts have argued that because the right to remain in the United States is an inherent right of citizenship, the only way for the Trump administration to force U.S. citizens out of the country, even temporarily, would be to strip those citizens of their citizenship. That would be an extraordinary, unprecedented action. But in the case of temporary confinement in a foreign country's prison, this is largely uncharted waters. And I'm sure the federal government would argue that if they maintain custody and control and merely subcontract out the prison terms of these inmates, that it would still qualify as U.S. soil or still qualify as remaining in the United States temporarily. And there's probably a spectrum of custody and control where it would be an open question. Again, these are uncharted territories that I don't think we want to be sailing in. Though spoiler, President Trump says he wants to do that too. But since we live in a timeline filled with extraordinary, unprecedented presidential actions, it's probably worth exploring in greater depth why the government can't just strip someone's citizenship away and force them out of the country. Now, the 14th Amendment of the U.S. Constitution states, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The 14th Amendment was enacted after the Civil War to address concerns about the rights of formerly enslaved people. The Citizenship Clause was included because in Dred Scott versus Sanford, the Supreme Court had held that enslaved people descended from Africans were not American citizens. The Citizenship Clause grants citizenship to everyone born in the United States, also known as birthright citizenship. And you guessed it, that provision is also being attacked by the Trump administration in the Birthright Citizenship Executive Order and the associated litigation. But courts have read the Citizenship Clause very broadly and only allowed for the removal of citizenship in very, very narrow circumstances. During World War II, Congress enacted the Nationality Act of 1940, which allowed citizenship to be stripped from anyone who served in a foreign military or government, if that person also had citizenship in that foreign country. It also mandated the loss of citizenship for people who deserted or evaded military service during wartime or who voted in a foreign election. But in Nishikawa versus Dulles, the provision calling for revocation of citizenship as a punishment for foreign military service was found to be unenforceable unless the government could prove that the service was voluntary. And the provision stripping citizenship for U.S. military deserters was considered in a case called Trope versus Dulles. In that case, it involved a natural-born U.S. citizen who was convicted of deserting during World War II. The Supreme Court ruled that stripping someone of their citizenship as a punishment for a crime was a violation of the Eighth Amendment's prohibition on cruel and unusual punishment. Notably, Justice Earl Warren said that revoking citizenship is, quote, a form of punishment more primitive than torture, and it inflicts a total destruction of an individual's status in organized society. In Ephraim versus Rusk, the Supreme Court confirmed that a person cannot lose citizenship unless they choose to voluntarily give it up. In that case, the Supreme Court considered the case of Beas Ephraim, who had been born in Poland and naturalized as an American citizen, but had then voted in Israeli elections. The court struck down the provision of the Nationality Act of 1940 that allowed the government to strip citizenship from someone in retaliation for voting in a foreign election. Writing for the court, Justice Hugo Black concluded that, quote, once acquired, this 14th Amendment citizenship was not to be shifted, canceled, or diluted at the will of the federal government, the states, or any other governmental unit. Now, forcing someone out of the territory of the United States against their will would violate a statute that Trump himself signed into law and would infringe on a person's 14th Amendment rights as a citizen to remain in the United States. And it's likely that if President Trump sends them to CCOT specifically, that would add another constitutional violation and break the United States' promises as a signatory of the Convention Against Torture. Now, the human rights abuses in CCOT have been well documented in the various lawsuits against the Trump administration, and we've already discussed them in several of our videos about those lawsuits. But I think it's important to recount them briefly again, disturbing as they are, because the details bear directly on the question of whether or not it would be legal to send a U.S. citizen there. Now, credible news reports and independent investigations have documented numerous human rights violations in CCOT, including 153 inmate deaths in a one-year period, many of which could be attributed to torture, beating, strangulation, and lack of medical attention. Autopsies have revealed patterns of cuts, hematomas, sharp object wounds, and signs of strangulation, and survivors of the prison report being subjected to electrocution and untreated infections. The prison has no windows, fans, or air conditioning despite hot, humid, tropical conditions, and prisoners are housed in overcrowded cells and are denied access to reading materials, familial visits, exercise, healthcare, and outdoor time. The United States Department of State issued a lengthy report on President Bukele's human rights violations in 2022, and the Department of State found that, quote, significant human rights issues included credible reports of unlawful or arbitrary killings, forced disappearances, torture and cruel, inhuman, or degrading treatment or punishment by security forces, harsh and life-threatening prison conditions, arbitrary arrest, and detention. Now, the Salvadoran prison conditions would almost certainly be violations of the Eighth Amendment's prohibition on cruel and unusual punishment. The Eighth Amendment reads, quote, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Supreme Court has ruled that use of excessive force against prisoners violates the Eighth Amendment. For example, in the case of Hudson versus McMillan, the Supreme Court ruled that force could be considered excessive even if the damage inflicted was minor. And from what we've heard about the injuries to prisoners in CCOT, their injuries are not minor. They are often life-threatening or even fatal. A 2024 report found that upon arrival in prison, detainees under the state of exception were, quote, beaten to pressure them to declare which gang they belonged to, and if they refused to say so, they were beaten and tortured more, some convulsed from the beatings they received, and others died in these practices on the first day of transfer. So it's hard to imagine a clear Eighth Amendment violation. Now, overcrowding and resulting lack of medical care are also violations of the Eighth Amendment's bar against cruel and unusual punishment. In Brown versus Plata, the Supreme Court actually mandated that the state of California reduce its prison population because the overcrowding was so severe. And as a result of the overcrowding in California's prisons, prisoners were unable to get mental or physical health care in a timely fashion, which the court affirmed amounted to an Eighth Amendment violation. Now, credible reports have indicated that prisoners in CCOT live in overcrowded cells and suffer from untreated medical ailments. And according to Dr. Sarah Bishop's declaration in the JJG versus Trump Alien Enemies Act case, quote, an analysis of CCOT's design using satellite footage found that if the prison were to reach full supposed capacity of 40,000, each prisoner would have less than 2 feet of space in shared cells, an amount the authors point out is less than half the space required for transporting mid-sized cattle under EU law. And within that same declaration, Dr. Bishop recounted testimony from a doctor who had worked in the prison and reported that inmates were not provided with medication to treat their pre-existing conditions, and the guards often ignored pleas for help by sick inmates, which sometimes resulted in death. Now, that too would almost certainly be impermissible under the Eighth Amendment. And the United States is also required to abide by the Conventions Against Torture. The Convention Against Torture states that, quote, no state party shall expel, return, or extradite a person to another state where there are substantial grounds for believing that he would be in danger of being subjected to torture. And there are ample grounds for the Trump administration to believe that torture is occurring in CCOT and other Salvadoran prisons. Human Rights Watch submitted a declaration in the JGG case detailing the abuses of Salvadoran prisons, including even the torture of children. And Amnesty International has also concluded that there is, quote, systemic use of torture in Salvadoran prisons. In 2022, our own Department of State found that there were credible reports that government officials engaged in torture. So again, it would be difficult for the Trump administration to claim that there aren't substantial grounds to believe that torture is occurring in Salvadoran prisons under Bukele's leadership. But what if, instead of doubling down on its agreement with Bukele, the administration decides to send American prisoners to some other less torture-filled prison outside of the United States. Would that be okay? Well, because of the 14th Amendment issues we've already talked about, this would likely not be allowed either. But there is one circumstance when the US government can send a US citizen to be imprisoned abroad, if there is a valid extradition treaty. In other words, if a US citizen commits a crime in another country and the United States has an extradition treaty with that country, then the US government may extradite its own citizen to that country in order to be tried under the other country's laws and potentially imprisoned there. But even in that instance, a US citizen must first be given a hearing within the US system to determine if there is sufficient factual evidence to support the other country's accusations. In Doe versus Mattis, the DC Circuit considered whether the first Trump administration could forcibly transfer an American citizen out of US military custody in Iraq to a third-party country. The unnamed plaintiff, Doe, was captured in Syrian territory controlled by the Islamic State and was then accused of being an enemy combatant working for the Islamic State. The Trump administration notified him that he was about to be transferred to the custody of a third-party country, and Doe, with the help of the ACLU, challenged this transfer. The DC Circuit relied on an earlier Supreme Court case, Valentine versus US, to find that even if someone has violated a law abroad, there is, quote, generally no executive discretion to surrender a person to a foreign government unless a statute or treaty confers the power. So unless someone is accused of a crime in a country where we have an extradition treaty, and they are given a proper hearing in which a US judge finds those accusations to be credible, the executive cannot simply ship a citizen off to another country, even if that country doesn't host torture prisons. But given the Trump administration's track record here, we don't expect that they're going to let minor things like statutes or the US Constitution stop them. And what about the deported US citizen children? Well, for one, initials VML, the federal court in Louisiana, and remember this is Judge Doughty, a very, very Trump-friendly judge, and you can tell this by some of the language that's being used in this particular order. He said, quote, before the court is a petition for writ of habeas corpus, an emergency motion for temporary restraining order filed on behalf of VML. VML is ostensibly a 2-year-old United States citizen. On April 24th, 2025, this court received a petition contending that VML was being deported alongside her illegal immigrant mother to Honduras. Of course, it is illegal and unconstitutional to deport, detain for deportation, or recommend deportation of a U.S. citizen, citing several cases affirming that a citizen has the absolute right to enter the United States borders. And citing another case, this court long ago recognized that the nature of our federal union and our constitutional concepts of personal liberty unite to require that all citizens be free to travel throughout the length and breadth of our land uninhibited by statutes, rules, or regulations which unreasonably burden or restrict this movement. The government contends that this is all okay because the mother wishes that the child be deported with her. But the court doesn't know that. Seeking the path of least resistance, the court called counsel for the government at 12:19 p.m. CST so that we could speak with VML's mother and survey her consent and custodial rights. The court was independently aware at the time that the plane, tail number N570TA, was above the Gulf of America. The court was then called back by counsel for the government at 1:06 p.m. CST, informing the court that a call with VML's mother would not be possible because she, and presumably VML, had just been released in Honduras. In the interest of dispelling our strong suspicion that the government just deported a U.S. citizen with no meaningful process, it is ordered that this matter be set for hearing at 9 a.m. on May 16, 2025. So I guess check back in 3 weeks. Now, if you do get renditioned off to a foreign country, the last thing you want, or maybe the second last thing that you want after getting sent to a torture gulag, is getting hit with a whole bunch of roaming fees on your cell phone, which you can avoid with today's sponsor, Saley. Saley is the best way to get high-speed data on your cell phone whenever you travel abroad or travel to places in the country without safe and secure Wi-Fi. Saley is an incredible new eSIM service app from your friends at Nord Security, so you know it's quality. It's a great alternative to buying a local SIM card because it works in 160 countries across 8 global regions, and clicking on the link or using my code LegalEagle will get you an exclusive 15% off discount of your first purchase. Now, if you've ever been lost abroad, whether you got renditioned or not, or only have access to sketchy public Wi-Fi that could steal your data, you'll understand what a difference a local SIM card can make. An eSIM provides you a secure internet connection whenever you travel, saving you tons of money on roaming fees and data overages. And by using a Saley eSIM, you never have to remember that all the photos and videos that you're going to take on vacation are now quietly uploading in the background, blowing up your data allowance and costing a fortune. Not that I have ever made that mistake. And with the Saley app, getting an eSIM for your iOS or Android device couldn't be simpler. You just buy a plan and activate it, all in the Saley app or on the website. And once you've got it activated, you're good to use the internet wherever you go without needing to pop into a cafe and pray that they have decent Wi-Fi with at least some security. And an eSIM with Saley saves you tons of time when it matters most. There's no need to wait in line at every airport to get a local physical SIM card because a Saley eSIM is entirely virtual. It just works. So click on the link below or use the code LegalEagle to get an exclusive 15% off your first purchase. A Saley eSIM really is a traveler's best friend, and it's the best decision you can make before going to another country. So click on the link below and get 15% off. And then after that, click on this video over here for more LegalEagle, or I'll see you in court. Release the Epstein files. No, wait, Epstein is actually a host. No, wait, since everyone is spending a ridiculous amount of time on this, I don't know why, just release all the grand jury testimony, even though that's not what people are asking for, and you can't do it without court permission, and the court will probably block that. Trump's "I'm not involved with Jeffrey Epstein" t-shirt has a lot of people asking questions already answered by his t-shirt. And the funny thing about that meme is that it was originally literally about human trafficking. But the long and short of it is that the MAGA movement may have finally taken a stand against the Trump administration.
The current DOJ under Pam Bondi is covering up crimes.
But back in 2024, candidate Trump made some promises about releasing these so-called Epstein files.
Would you declassify the Epstein files?
Yeah, I would.
During his most recent presidential campaign, Trump said that he would have, quote, no problem looking into the Epstein client list.
The list of clients that went to the island has not been made public.
Yeah, it's very interesting, isn't it? But yeah, I'd be inclined to do the Epstein. I'd have no problem with it.
Then Attorney General Pam Bondi told everyone that Epstein's legendary client list was right there on her desk. Except it wasn't. Pam Bondi released a 2-page memo saying that actually Epstein did just kill himself, there's no secret client list, and there are no more documents that are going to be released. And everyone believed her, and that was the end of the story. No, I'm just kidding. Trump supporters weren't having it at all. Even Trump's reliable buddies over at Fox News aren't buying the narrative.
Why do you say he's become the deep state?
What is more deep state than covering up for pedophiles?
And Trump took to Truth Social to post a long screed proclaiming how great Bondi is and telling everyone to, quote, not waste time and energy on Jeffrey Epstein, somebody that nobody cares about. Except that a whole bunch of people care a whole lot about Epstein.
Make some noise if you care about the Jeffrey Epstein scandal.
Raise your hand if it matters a lot to you. Raise your hand. So every hand of 7,000 people.
And now we live in a world where Congress's resident Jewish space laser enthusiast Marjorie Taylor Greene and Silicon Valley progressive Ro Khanna might finally agree on something. And meanwhile, while all this was playing out in the media, the Trump Department of Justice finally acted on Ghislaine Maxwell's plea for the Supreme Court to overturn her conviction after months of delay. Oh, and now Donald Trump is threatening to sue, quote, the ass off of Rupert Murdoch. He's furious because the Wall Street Journal published a story last night about Trump sending Jeffrey Epstein a handwritten birthday card in 2003, where Trump hand drew sketches of a naked woman and then made his signature mimic pubic hair, and which Trump ends the letter with, quote, happy birthday and may every day be another wonderful secret. So suffice to say, there is a lot going on here, both in the media, in the government, and in the courts, and a lot of suspicious timing with how the Trump administration is playing this, and baffling statements from Trump himself. So as the MAGA world implodes, let's take a step back and talk about how we got here, what the Epstein files actually are, and what they are not. And make no mistake about it, apart from all of the fabricated conspiracy theories, the Epstein saga does point to an actual real-life conspiracy that spits in the face of anyone who cares about equal justice and the rule of law in this country. But from the very beginning, everything that touched Jeffrey Epstein reeked of corruption. In 1996, Maria Farmer, an artist in her mid-20s, reported to the NYPD and the FBI that Epstein and his associate, British socialite Ghislaine Maxwell, had violently sexually assaulted her while she was visiting his property in upstate New York. Farmer claims that she also warned the FBI that Epstein and Maxwell had committed multiple serious sex crimes against girls, including her minor sister, that Epstein stole nude and partially nude photos of 2 of her minor sisters, and that he possessed child pornography. But neither law enforcement agency followed up on Farmer's complaint. And nearly a decade later, in March of 2005, a woman reported to the Palm Beach police that her 14-year-old stepdaughter had been molested by a wealthy man. In subsequent police interviews, the girl confirmed that she had been recruited by a female classmate, also an undergrad, who had done sexual favors for Epstein in exchange for money. That classmate apparently took the 14-year-old complainant to Epstein's house, where his staff escorted her to his bedroom. Epstein appeared in nothing but a towel and told her to undress and then massage him, and during that massage, he sexually abused her. Now, the unnamed complainant came from a rough background. The underage classmate who recruited her had recently been sexually assaulted before she met Epstein, and this would become a pattern for Epstein. He preyed on girls from poor, violent, and troubled backgrounds, sexually abused them in exchange for money, and then paid them to recruit similarly troubled girls for him to abuse. Now, when Palm Beach detective Joe Ricari began conducting witness interviews, Epstein was quickly tipped off by one of the potential witnesses. Epstein then hired his own private investigators who sought out victims and witnesses often before they were even contacted by the police. Detective Ricari still managed to identify 17 victims, all in the 14 to 20 age range, all of which recounted a similar fact pattern of the original 14-year-old victim. Recruitment by another girl or woman, ostensibly to give Epstein massages in exchange for money, being told to undress, and then being sexually assaulted or groped, being paid for the massage and sexual interaction, and being offered compensation to find future victims. Now, based on the overwhelming testimony, Detective Ricari provided the state's attorney's office with probable cause affidavit drafts for felony sexual offenses for Epstein and 2 of his female recruiters. State's Attorney Barry Kreischer, though, declined to talk to any victims or parents and decided that 17 witnesses just wasn't enough to make a case. So Kreischer offered Epstein a sweet plea deal. When Epstein rejected that, Kreischer made the highly unusual choice to take the matter to a grand jury. Typically, a state's attorney would simply charge and arrest the accused. But during the grand jury proceedings, the prosecutor, Lana Belahovlik, invited only 2 victims to testify before the grand jury, and it appears that Belahovlik actively undermined her own witnesses by peppering the girls with questions about unsavory social media posts and even accusing a 15-year-old victim of being a prostitute. Now, the state's attorney's office was also in close communication with Epstein's defense attorneys. And in fact, it was Epstein's attorneys who provided the prosecutors with the underage girls' questionable social media posts, which the prosecutors then used to bully their own underage witnesses. And in the end, the grand jury returned only a single charge: felony solicitation of prostitution, which said nothing about the girls being underage. Now, if you're infuriated by this, you're not the only one. Detective Ricari's boss, Palm Beach Police Chief Michael Reiter, one of the few good guys in this sordid story, was also furious enough at the state's attorney's actions that he sent a scathing letter to Kreischer stating, quote, "After giving this much thought and consideration, I must urge you to examine the unusual course that your office's handling of this matter has taken and consider if good and sufficient reason exists to require your disqualification from the prosecution of these cases." Detective Ricari also took the extraordinary step of going to the FBI to ask them to prosecute the case, since the state's attorney had done such a poor job. But the feds agreed to launch their own investigation. One can only speculate that this was because they already had a file on the guy from 1996 and probably wanted to save face, but we'll never know. But the FBI's reinvestigation turned up evidence of additional victims, including 34 confirmed minors. And the victims reported the same fact pattern of massages and sexual abuse. The feds found pictures of many of Epstein's victims in his house, as well as plenty of other corroborating evidence tying him to numerous underage victims. And armed with this mountain of evidence, the feds sharpened their lawyers' war axes and offered Epstein a slap on the wrist plea deal that should have made national headlines as a travesty of justice, but it did not. Now, back in 2007, we didn't have the tools we have today to get a bird's eye view of how the Epstein slap on the wrist spread throughout the media and public sentiment. But when you use modern technology, you can see the massive political earthquake over Epstein in real time. We can see that there have been 372 stories about Epstein in the last 3 months, with 46% of the coverage coming from right-leaning sources, 24% coming from the center, and 30% coming from the left. And if you take a closer look at specific stories like the reporting from Wired that revealed editing in the security camera video of the night that Epstein died, you see a fascinating breakdown of how attitudes across political divides are rapidly changing. This story was only covered by about 50 sources, with 40% of the coverage coming from the right. On the left, sources mostly frame the missing footage as critical minutes that point to a larger cover-up and possible conspiracy. On the right, sources largely agreed with the left that the missing footage was critical, and were even more likely to embrace the yet unverified as of this recording claims that there exists even more missing footage. And in the center, sources typically focused on the problematic nature of the missing footage, but were not as likely to point to a cover-up. Now, headlines and coverage vary greatly depending on the source, which is why I use today's sponsor, Ground News. The Nobel Peace Center called Ground News an excellent way to stay informed, avoid echo chambers, and expand your worldview. They've been a longtime supporter of this channel and independent journalism at large. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. Now, one of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. And I also love their blind spot feed, which shows you stories that are underreported by either side of the political spectrum. But all this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. So click now or I will see you in court. But let's get back to 2007, when Jeffrey Epstein was offered the sweetheart plea bargain deal of the century. In June of 2007, the local U.S. Attorney's Office, under the leadership of Alex Acosta, issued a 53-page indictment against Epstein. Now, negotiations for a plea deal began with Epstein's all-star legal team: Ken Starr, famous for serving as independent counsel during the impeachment of Bill Clinton; Alan Dershowitz, famous for lots of stuff; and Jay Lefkowitz, a partner at Kirkland & Ellis, the same law firm where Acosta was previously a partner. And after a lot of cozy meetings with defense attorneys at hotels over breakfast, Acosta offered Epstein a remarkable deal. Epstein could plead guilty to state charges: 1 count of solicitation of prostitution and 1 count of solicitation of prostitution with a minor under the age of 18. He would be sentenced to 8 months in jail following a year of house arrest, and be adjudicated as a convicted sex offender who must register twice a year in Florida. And that was it. That was the penalty for sexually abusing at least 34 underage girls in a systematic, calculated way for years. And even then, Epstein only spent his evenings in Florida jail. During the day, he was permitted work release at his swanky office building. Now, Acosta's deal with Epstein included several other gifts fit for a king of Wall Street. an agreement that the victims would not be notified, a promise that the deal would be kept under seal, and an agreement to dismiss all grand jury subpoenas. And Epstein's all-star legal team also managed to secure one more extraordinary victory: a non-prosecution agreement which allowed Epstein and his co-conspirators to avoid federal sex trafficking charges. Now, we've covered this before, but this plea deal was extraordinary for several reasons. First, 18 U.S.C. 3771, the Crime Victims' Rights Act, gives victims the right to be apprised of the developments in criminal proceedings, the right to be present at public proceedings, and the right to be heard related to plea deals, sentencing, and other key developments. Now, the prosecutors not only bypassed any notification of the victims, but they actively lied to the victims, sending them a letter months after the plea deal had already been signed, urging patience while the prosecution, quote, conducts a thorough investigation. Now, bypassing this law at the request of a serial sex abuser's attorneys was an extraordinary move by Acosta's part. Now, second, Acosta's agreement with Epstein not only prevented future prosecutions of Epstein, but also future prosecutions of his 4 named co-conspirators in an open-ended category of, quote, any potential co-conspirators. Another extraordinary gift. Now, both of these aspects of the agreement are legally important, but we'll get to that in a second. Now, the Miami Herald really blew the lid off of this entire story and reported that the plea deal may have been affected by Epstein's role as a witness in the 2008 securities fraud case against Bear Stearns executives. Now, ironically, those executives were later acquitted, along with pretty much anyone else who played a direct role in blowing up our economy. Now, we don't know for sure, but it looks like prosecutors threw a couple dozen underage girls under the bus in order to get some ineffective testimony about the cheating finance execs who tanked the world economy. So Jeffrey Epstein served 13 months of nighttime imprisonment, spent his days at his swanky office, and apparently even continued to have women flown out to Palm Beach to have sex with him in exchange for money. And a few potential violations of the house arrest were documented in the state's attorney's files, but no one took action. And after his 13 months were up, Epstein seemed to return to his ordinary life of sexual predation. And faced with some additional law enforcement scrutiny, he purchased 2 private islands off the coast of the US Virgin Islands in 2010 and 2016, respectively, where he then had even more leverage over his victims. In a later lawsuit, one of his victims revealed that in an act of desperation, she tried to swim off the island to escape him. But Epstein and his co-conspirators located her and then took her passport in an attempt to keep her captive. Another victim alleged that when she tried to escape the private island, Epstein and his co-conspirators returned her to his house and suggested physical restraint or harm if she failed to cooperate. And meanwhile, U.S. Attorney Alex Acosta went on to be appointed as Trump's Secretary of Labor.
On behalf of the President of the United States, it's my honor to welcome you all today to the office of the Vice President here at the White House complex for a very important moment in the life of this administration and in our national life, as I administer the oath of office to the 27th Secretary of Labor for the United States of America, Alexander Acosta.
And all the bad guys lived happily ever after. Until 2 scrappy reporters, a few more heroes in the story, started looking into this. Julie K. Brown, an investigative reporter at the Miami Herald, and Miami Herald videographer Emily Michaud began investigating Epstein in early 2017, about the same time as Acosta was being nominated as Secretary of Labor by Donald Trump in his first term. And they uncovered 80 potential victims as young as 13 and 14 years old when the abuse occurred, and conducted video and written interviews with 8 survivors, the most important heroes in the story, who bravely agreed to tell their stories. And the Miami Herald's investigation ultimately led to Acosta's resignation from his Secretary of Labor role, and finally to a real criminal indictment against Jeffrey Epstein. So on July 6, 2019, federal prosecutors in New York got a second chance to prosecute Epstein. And unlike Bill O'Reilly, you're probably smart enough to figure out that since this is 2019, this is still the Trump administration. Epstein was arrested at Teterboro Airport in New Jersey, reportedly a hub of his sex trafficking network, and under 18 U.S.C. 1591, the U.S. Attorney's Office for the Southern District of New York charged him with sex trafficking and sex trafficking conspiracy related to the abuse of dozens of minor girls at his properties in Palm Beach and New York. Now, the Southern District of New York's charges weren't double jeopardy because in Acosta's original case, Epstein only pled to state-level charges, and the 2019 indictment included only federal charges. Acosta's plea agreement with Epstein, though, would have likely become a thornier issue. But the U.S. attorneys never had to address that because on August 10, 2019, Epstein was found dead in his cell. A medical examiner's report ruled it a suicide by hanging. So obviously that ended the criminal prosecution against him, but it did not stop the legal fallout. Now, Maria Farmer and several other Epstein victims alleged the involvement of Epstein's longtime companion, Ghislaine Maxwell. Victims accused Maxwell of recruiting them, manipulating and gaslighting them by normalizing Epstein's predatory behavior, and even of sexually abusing them herself. And the Department of Justice's investigation corroborated this, finding that Maxwell and Epstein identified vulnerable girls, typically from single mother households and difficult financial circumstances. Maxwell then helped Epstein entice and recruit the girls as young as 14 to visit Epstein's Palm Beach residence to be sexually abused by him. Maxwell also encouraged victims to travel to Epstein's other properties, knowing that they would be sexually abused there, and she helped pay victims for the sex acts and for recruiting other additional girls to be similarly abused by Epstein. And on December 29, 2021, Maxwell was found guilty of conspiracy to entice minors to travel to engage in illegal sex acts, conspiracy to transport minors to participate in illegal sex acts, transporting a minor to participate in illegal sex acts, sex trafficking conspiracy, and sex trafficking of a minor. Now, numerous powerful men and female co-conspirators have been named in connection with Epstein's sex crimes, but Maxwell remains the only person in the United States who was ever actually convicted of sex crimes related to the Epstein abuses. She was sentenced to 20 years in prison. But Maxwell may still evade justice thanks to Acosta's plea agreement with Epstein. In a 2023 appeal to the United States Court of Appeals for the Second Circuit, Maxwell argued that because Acosta's immunity deal with Epstein included an unnamed list of co-conspirators, and because Acosta didn't expressly limit the agreement to the Southern District of Florida, she should be included and should be immune. The DOJ has counter-argued that, quote, the phrase United States in a plea agreement like this is just a generic reference to the U.S. Attorney's Office that enters into the agreement and is not on its own enough to establish an affirmative appearance. The DOJ also argued that Maxwell has no right to invoke the protections of the agreement because she wasn't a signatory to the agreement and hadn't sufficiently argued its protections were conferred onto her. Now, the Second Circuit Court of Appeals affirmed Maxwell's conviction, but in April 2025, Maxwell filed a petition for writ of certiorari with the Supreme Court, asking the court to find that Acosta's sweetheart deal applied to her as well. Maxwell argued that there's a circuit split as to whether a promise on behalf of the United States or the government by a United States Attorney's Office in one district is binding upon offices in other districts. Now, confronted with this challenge, the Trump DOJ did nothing for 3 months, but mere days after Trump's meltdown on Truth Social, Trump's DOJ filed a conveniently timed response to Maxwell's petition for writ of certiorari, arguing that the plea deal did not apply to her. And the DOJ contended that, quote, at the time the NPA was negotiated, DOJ policy barred U.S. attorneys from entering into non-prosecution agreements that bound other districts unless they obtained the approval of those districts or the criminal division. And it would be strange if one rogue district attorney could bind the entire U.S. government from ever filing charges against Epstein or his co-conspirators without ever consulting headquarters. But as of the recording of this video, the court hasn't decided whether it will hear Maxwell's case or not. And meanwhile, the many civil actions against Epstein's estate and associates continue. And for everyone out there hungry for names to be named, well, we have some good news. Thanks to how our justice system works, lots of names have been named in the civil cases. These are the true Epstein files, and we've gone through them so you don't have to. One of the bravest and most vocal survivors was Virginia Roberts Giuffre. Giuffre was involved as a pseudonymous plaintiff in one of the first batch of civil lawsuits against Epstein in 2009. In 2011, she revealed her identity as a survivor of abuse by Epstein and Maxwell. And she went on to file several lawsuits, including one against England's Prince Andrew for sexual abuse when she was 16 and 17, which resulted in an undisclosed settlement. In depositions and public statements, Giuffre has claimed many times that Maxwell recruited and groomed her for sexual abuse. Maxwell vehemently denied this and publicly called Giuffre a liar, and in response, Giuffre filed a defamation lawsuit against Maxwell. The case settled in 2017, but the case generated reams of documents, including depositions, pictures, communications, and a vast trove of other evidence. These and other documentary evidence generated in other civil and criminal cases are the real Epstein files. And in early 2024, the court in Giuffre versus Maxwell ordered the unsealing of many of these documents. These documents had previously been sealed to protect the identities of many of Epstein's victims who still have not publicly identified themselves. Many of the documents contain not just names, but also identifying information about people's backgrounds, personal details that could have been used to re-identify victims. And court documents are often sealed in cases involving sexual abuse, especially the sexual abuse of minors, because the documents can contain exceptionally private and troubling details, which, especially in a post-internet world, could affect the victim's safety. Indeed, in their depositions, several of Epstein's victims said that after their identities became public, they feared for their safety. But the documents in the Giuffre case were unsealed because there was an exceptionally strong public interest in the case and because Giuffre herself had argued that they should be unsealed. Maxwell's legal team argued vehemently against the unsealing of the documents, despite the fact that Maxwell had already been convicted years before. But this highlights a key tension in the case, the balance between the victim's need for privacy and the public's need to hold Epstein's co-conspirators accountable. And this tension is particularly strong in the Epstein case because many of the girls involved were not only victims themselves, but were also paid to recruit future victims. Even still, many redactions were applied to protect the identities of victims who have still never publicly identified themselves and feared for their safety if they were named. And many prominent people were also named in the unsealed documents, but they had all been previously identified as Epstein associates. Giuffre's unsealed deposition detailed several times that Epstein directed her as a minor to have sex with prominent men, including Epstein's attorney, Alan Dershowitz, former Governor Bill Richardson, former Senate Majority Leader George Mitchell, CEO Les Wexner, Prince Andrew, MIT scientist Marvin Minsky, hotel company heir Thomas Pritzker, and billionaire Glenn Dubin. And all these men, except Minsky, who died in 2016 before Giuffre's allegations against him were public, have denied these charges, and none have been criminally charged. And the accusation against Dershowitz was particularly contentious. He and Giuffre both sued each other for defamation, agreeing in 2022 to settle their lawsuits against each other. And immediately after the settlement, Giuffre released a public statement saying that she, quote, may have made a mistake in identifying Mr. Dershowitz, but she later clarified that she, quote, did not and would never exonerate Mr. Dershowitz. The Giuffre's case was one of the many against Epstein and his associates. And companies tied to Epstein, including JP Morgan Chase, Deutsche Bank, and Barclays, have also been sued for turning a blind eye to obvious signs of human trafficking. And Epstein's estate has also paid out several $100 million in settlements to various parties, including victims and the government of the U.S. Virgin Islands. A voluntary victims compensation fund set up by Epstein's estate has paid out more than $120 million to 136 survivors of Epstein's sex trafficking network. And another 52 women filed and privately settled claims outside of the compensation fund. The documents and statements associated with these lawsuits, though, have revealed a plethora of additional information about Epstein and his sex trafficking patterns. One important pattern is that Epstein also often dangled not only money, but his social connections in order to lure his victims into his orbit. And Epstein was quite wealthy and very well connected to CEOs like Les Wexner of Victoria's Secret parent company L Brands, to politicians like Bill Clinton and Donald Trump, to arts patrons like Eileen Guggenheim, to universities like Harvard and MIT, and even to scientists like Stephen Hawking. And to be clear, many, if not the vast majority of these people, were never involved in Epstein's trafficking operation, but part of his ability to evade capture and his ability to manipulate his victims was based on his long list of powerful friends and acquaintances. To Maria Farmer, he offered an introduction into the art world. To other girls, he offered help with their modeling careers, and to some, he offered help to further their education. And it's reasonable to conclude that Epstein's ability to evade accountability in 2006 was probably due to his wealth and connections. He was able to leverage those resources to hire the best attorneys, who in turn had connections to the prosecutors' offices. But MAGA and QAnon conspiracy theorists took those actual facts and blew them into fantastical conspiracy theories, which President Trump and his allies often encouraged. And last week, that practice of fanning the flames of conspiracy theories and making fantastical promises came back and bit President Trump and his administration where it counts the most: the rabid credulity of the MAGA base. Now, since Epstein's death, all manner of wild conspiracy theories have bloomed under the MAGA and QAnon communities. The Epstein scandal actually fit quite well with QAnon's core belief that there's a cabal of satanic cannibalistic child molesters in league with the deep state, which is operating a global child sex trafficking ring. And to the extent that MAGA isn't synonymous with QAnon, conspiracy theories ran rampant in MAGA land as well, including the idea that the Clintons had murdered Epstein. Though QAnon curiously never saw the sex trafficking in their own house. Other MAGA figures like Tucker Carlson promoted the idea that Epstein was actually an intelligence asset, possibly of Israel's Mossad.
It's extremely obvious to anyone who watches that this guy had direct connections to a foreign government. Now, no one's allowed to say that that foreign government is Israel because we have been somehow cowed into thinking that that's naughty.
And that theory had some nice overlap with anti-Semitic conspiracies because Epstein and Maxwell were also ethnically Jewish. Dan Bongino, now deputy FBI director, has been promoting this conspiracy theory for years.
Which Middle Eastern countries they are, I don't know, but this person, who's a very, very good reporter, I mean, aces, right, swore Epstein was either a witting or unwitting intelligence asset, and they may have had his plane wired up, and they're the ones who have all this stuff.
And Megyn Kelly just endorsed it again on June 16th.
Do you think there's any intel community involvement in this?
I wouldn't be surprised one bit. Well, I mean, it's possible that that's the reason everything's getting buried, that there is some treasure trove, and it's getting buried because...
How many people here believe that? Raise your hand. Okay, I'd say about half the hands think that it's being buried because of an Israeli thing.
And MAGA figures frequently promoted the idea that Epstein had a list of powerful elite men, always liberals for some reason, that had been involved in the sex trafficking, possibly so that he could blackmail them. And the kernel of truth that likely inspired this conspiracy theory was that one of Epstein's employees, Alfredo Rodriguez, did once try to sell a notebook with a list of names in it, but that notebook contained the names and contact information about Epstein's victims, not his associates. Rodriguez was later convicted of obstruction of justice and sentenced to federal prison. The contents of the black book was evidence in several civil lawsuits. And Rodriguez, by the way, was sentenced to the same amount of time that Epstein ended up serving as a result of a Costa's sweetheart deal. Now, President Trump has rarely encountered a conspiracy theory he didn't like. And in August of 2019, during Trump's first term, just after Epstein's death, Trump reposted a tweet suggesting that Clinton or George Soros had murdered Epstein. So when AG Pam Bondi's DOJ came out with a 2-page memo declaring that there was nothing to see, that Epstein's death was a suicide, and there was no secret client list or cabal of liberal elite sex trafficking children, the MAGAverse lost its collective mind. Dan Bongino had a spirited disagreement with Pam Bondi and threatened to maybe possibly quit his job. Apparently he was on the verge of making a stand. Laura Loomer warned Trump that this misstep could consume his presidency and called for a special counsel's investigation. Glenn Beck declared that he wanted Pam Bondi fired.
Okay, I want Pam Bondi fired. I want Pam Bondi fired.
Megyn Kelly called for Bondi to resign and declared that if she didn't, some MAGA bros would leave.
We're calling for Pam Bondi to resign or to go, but can you please tell people the breaking news? According to reports that you have verified, Kash Patel and Dan Bongino will resign if what does not happen?
If she doesn't go.
And even House Speaker Mike Johnson said he supported the release of the Epstein files. And it seemed that the Democrats were finally happy to find something to do. Senator Ruben Gallego accused President Trump of, quote, hiding the Epstein list. House Minority Leader Hakeem Jeffries proclaimed that Americans, quote, deserve to know the truth. And on Tuesday, Democrats attempted to cast a procedural vote as to a referendum to compel the release of more Epstein-related material. And none of that was helped by the real questions raised by the Epstein jail cell video that the Trump administration released. As Wired has reported, nearly 3 minutes were cut out of the released video. Bondi has claimed that this is because of the way that the videos turn over at the end of the day, but Wired's experts confirmed that the video was edited, and my video editors tell me that it was a rookie move to leave that in the metadata. And President Trump, faced with the ire of some of his supporters and insults from his enemies, went on the offensive, posting a long screed on Truth Social about how his Republican critics were just playing into the hands of the, quote, radical left Democrats, and he called his doubtful previous supporters weaklings and proclaimed that he didn't want their support anymore. And it appears that Trump and his inner circle engaged in their own real-life Epstein conspiracies. One was to stifle right-wing news from talking about the Epstein files. Reports are that Trump and his inner circle tried to strong-arm the press from talking about Epstein, which apparently largely worked. And another is that Trump fired Maureen Comey, daughter of James Comey, who had worked at the U.S. Attorney's Office for nearly a decade and helped prosecute both Jeffrey Epstein and Ghislaine Maxwell. I mean, I don't think this really changes anything. We've got plenty of tapes where Trump talks about his friend Jeffrey Epstein and Jeffrey Epstein talks about his friend Donald Trump. But yeah, that looks pretty terrible. But then, late last night, Trump posted, quote, based on the ridiculous amount of publicity given to Jeffrey Epstein, I've asked Attorney General Pam Bondi to produce any and all pertinent grand jury testimony, subject to the court approval. This scam perpetrated by the Democrats should end right now. But the thing is, as Congressman and former federal prosecutor Daniel Goldman points out, grand jury testimony is both very specific and isn't what people were asking for and wouldn't be the most relevant documents. And in fact, he tweeted, quote, nice try, AG Pam Bondi. What about videos, photographs, and other recordings? What about FBI 302's witness interviews? What about texts and emails? That's where the evidence about Trump and others will be. Grand jury testimony will only relate to Epstein and Maxwell. And in any event, as President Donald Trump cannot order the DOJ to unilaterally release sealed grand jury testimony. In fact, the Federal Rules of Criminal Procedure Rule 6E3E states that, quote, the court may authorize disclosure at a time, in a manner, and subject to any other conditions that it directs of a grand jury matter when, 1, preliminary, 2, or in connection with a judicial proceeding, 2, at the request of a defendant who shows that a ground may exist to dismiss the indictment because of a matter that occurred before the grand jury, 3, at the request of the government when sought by a foreign court or prosecutor, 4, at the request of the government if it shows a matter may disclose a violation of state, Indian, tribal, or foreign criminal law, and 5, at the request of the government if it shows that the matter may disclose a violation of military criminal law. Now, President Trump wanting AG Pam Bondi to release sealed proceedings from a grand jury because of political pressure seems like it fails to meet any of those requirements. And even Trump's post recognizes that the release of these documents must be made with court approval. And I'm not going to engage in conspiracy theories, but who knows? Maybe Trump doesn't want the court to approve the disclosure. But in any event, hopefully by now you understand that the sealed grand jury proceedings are probably not the real Epstein files to the extent they exist. But the real Epstein files are now largely public and aren't what people think. The real Epstein files are the thousands of pages of documents that have been generated by the criminal investigations and by civil lawsuits against Epstein and Maxwell. And some of these were unsealed in the Giuffre case, but many are still under seal. And it's likely that there are reams of witness interviews, financial statements, flight logs for Epstein's plane, records regarding his friends and acquaintances and co-conspirators, and photos and videos, including the child pornography that the Fed seized from his house. But while Megyn Kelly and Alan Dershowitz and others are calling for the unsealing of these documents, there are some very real reasons to keep many parts of those files secret. Not to protect the potential perpetrators, but to protect Epstein's hundreds of underage victims. But even if President Trump wanted to unseal these civil court documents, he can't do that unilaterally. The Department of Justice could file a motion in the relevant cases, and the judges could consider them, but because of the privacy and safety concerns, a judge might not necessarily grant the request to unseal. And if Trump were to declassify the federal criminal case files, there would also be legal implications. When the Trump administration released the JFK files, they accidentally disclosed a bunch of social security numbers. Any Epstein files would threaten to disclose even more private details about underage girls, potentially exposing them to yet more traumatic experiences and putting them at risk of harassment or physical violence. And there are laws, including the Privacy Act, which prohibit the government from disclosing private information about individuals without their consent. One important aspect of the Giuffre case is that Giuffre argued in favor of unsealing. She consented to it. It was an empowered choice that she made, which, when you're considering the rights of survivors, is important. So if you're looking for a real scandal in all of this, it's right there in plain sight. The real scandal is the consistent miscarriage of justice that's played out over the past 30 years. And while hundreds of victims have been identified and numerous powerful men have been implicated, only one person, Ghislaine Maxwell, has ever been convicted of sex crimes related to Epstein's decades of sexual abuse. And the sweetheart deal from one of Trump's prior cabinet secretaries may end up resulting in her escaping justice too. But all this highlights the massive gap in the justice system, which is one of the reasons I started my law firm, the Eagle Team, and one of the reasons I'm proud to fight for the little guy. Because after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. People would email and ask, Devin, can you help me find a lawyer? Or how do I know if this attorney is any good? Because it's not just that legal help is expensive, though it absolutely is. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up either doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I asked myself, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of just chasing billable hours. A firm where you don't need to pay anything up front because your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. I realized I was in a unique position. I had this platform, this community, and the experience. And that's why we started Eagle Team. Not to get rich. Trust me, there are way easier ways to make money than starting a law practice. We did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. So when you work with my firm, you're not just getting a lawyer, you're getting a team that understands that behind every case is a real person with real stakes. And if we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located exactly where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, or a trucking accident, a data breach, sexual harassment, or a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Look, obviously I can't represent everyone who watches this channel. I wish I could. But what I can do is make sure that when you need legal help, you'll have someone to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we've partnered with, you get the same principles of honesty and education that we bring to every video. So if you're dealing with a legal issue and you're not sure where to start, check out the link in the description or call the phone number that's on screen. Let's have a conversation about how we can help you find not just any lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about. Making sure that when life gets complicated, you don't have to face it alone. Which is why if you need a lawyer, you don't just need a legal team, you need the Eagle Team. And after you've dropped us a line and get yourself a great lawyer, click over here to watch more Legal Eagle, or I'll see you in court. Thanks to Skillshare for keeping Legal Eagle in the air. Learn to think like a lawyer for free for 2 months by clicking the link in the description. Attorney General William Barr wrote a 4-page summary of the Mueller report. Here are the 9 reasons I don't think it makes any sense. Hey Legal Eagles, today we're talking about the Barr letter. This is not the Mueller report, as a lot of people have reported. This is a summary of the Mueller report as conveyed by the Attorney General. The Barr letter purports to summarize the findings of Special Counsel Robert Mueller and his investigation into the Trump campaign and potential ties to Russian interference with our election. When the Barr letter came out on Sunday, I, like many Americans, read it cover to cover. But there were a couple things that stuck out to me as an attorney that just didn't make any sense. So here are the 9 things that I don't think make any sense in the Barr letter. Number 1. Why does the Barr letter only cover 2 of the 3 facets of the Mueller report? You might recall that Robert Mueller was tasked with investigating 3 things: a criminal investigation into potential ties with Russia, a criminal investigation into potential obstruction of justice by the president, and number 3, a counterintelligence investigation into Russian interference with the American election. But the Barr letter only deals with 2 of the 3 facets of the Mueller report and doesn't actually deal with the counterintelligence portions of the Mueller investigation. Why is that information missing from Barr's letter? Barr could have easily provided a summary of the counterintelligence portion of the investigation, but for some reason he chose not to. Why is that information not there? And we also learned that Barr is going to make a separate summary that can only be given to the Gang of Eight instead of the full intelligence committees of the House and the Senate. So why is there information that can only be provided to the Gang of Eight when a summary, even a top-level summary, can't be provided in the letter that is released to Congress in general and to the American people? Number two, what does Barr mean when he says that the Mueller report, quote, did not establish, end quote, a conspiracy with the Russians? What does it mean to not establish in this context? The Barr letter quotes a portion of the Mueller report stating that, quote, the investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. The problem is that this phrase can mean wildly different things. Does it mean that there was no evidence at all? Or does it mean that there is a boatload of evidence, but there is not quite enough to meet the standard of beyond a reasonable doubt that is necessary for a criminal prosecution? If a prosecutor says that an investigation did not establish something, it doesn't mean that that thing did not happen. It doesn't even mean that the prosecutor doesn't think it happened. It means that the investigation didn't produce enough information to prove beyond a reasonable doubt in front of a jury that that thing happened. So in this particular context, we don't know which of those potential outcomes there is. Is it that there is absolutely no evidence, or that there is evidence but not quite enough to meet the legal standard for a criminal prosecution? The difference between those two things is incredibly large and is very important as it regards what Congress is supposed to do next with this investigation. Number three, why does Barr suggest that there can be no obstruction of justice when there isn't a conviction for an underlying crime? Attorney General Barr suggests in his letter that you cannot have a conviction of obstruction of justice when there is no underlying criminal act or a conviction for an underlying criminal act. But that's simply not the case. A conviction for an underlying criminal act is not necessary for a conviction of obstruction of justice. Just talk to Martha Stewart, Barry Bonds, Bill Clinton, or Kwame Kilpatrick. The last example is especially illustrative because former Detroit Mayor Kwame Kilpatrick went to jail for obstruction of justice in 2008 after he lied under oath about having an extramarital affair. Having an affair is not an illegal act, but it's often embarrassing, especially for politicians, and they can go to jail for obstructing justice to prevent that information from coming out. This is especially worrying because Barr wrote a now famous, perhaps infamous, 19-page memo laying out a very idiosyncratic view of obstruction of justice. In the 19-page memo, Barr opined that, quote, the president's motive in removing Comey and commenting on Flynn could not have been corrupt unless the president and his campaign were actually guilty of illegal collusion. The vast majority of legal scholars agree that this is simply not the case, that even in the absence of an actual guilty verdict of illegal collusion or conspiracy or coordination, that is not necessary as a predicate for obstructing justice into that investigation. But that brings me to point number 4. Why does Attorney General Barr think that there was no crime? Even taking Attorney General Barr's idiosyncratic view of obstruction of justice at face value, even so, there was crime that was found in the Mueller investigation and throughout the investigations into the president. President Trump is effectively an unindicted co-conspirator in a felony campaign finance violation with Michael Cohen. Hiding, or at least preventing the investigation into that embarrassing affair and illegal conduct is more than enough reason to obstruct justice and can give rise to the corrupt mental state necessary to be guilty of obstruction of justice. Potentially that investigation was farmed out to the Southern District of New York, but even still, that is potential criminal conduct that could give rise to obstruction of justice. Not to mention all of the other convictions of Papadopoulos, Manafort, and Flynn. So the question is, why would Barr or Mueller himself limit the crime at issue to the very narrow definition of Russian conspiracy that was talked about in the Barr letter? I don't think that makes any sense. Which takes me to point number 5. Why didn't Robert Mueller decide the obstruction issue? The Barr letter states that, quote, after making a thorough factual investigation into these matters, the special counsel considered whether to evaluate the conduct under department standards governing prosecution and declination decisions, but ultimately determined not to make a traditional prosecutorial judgment. The special counsel therefore did not draw a conclusion one way or the other as to whether the examined conduct constituted obstruction. That doesn't sound like Robert Mueller declined to prosecute because of the facts, or that there wasn't enough evidence, but because of some countervailing legal issue, perhaps because of the DOJ policy not to indict the sitting president. But the Barr letter goes on to state that, instead, for each of the relevant actions investigated, the report sets out evidence on both sides of the question and leaves unresolved what the special counsel views as difficult decisions of law and fact concerning whether the president's actions and intent could be viewed as obstruction. To me, that doesn't make any sense. If the facts were 50-50, what we call equipoise in the law, that doesn't meet the standard of beyond a reasonable doubt. When there is some evidence, but not enough to reach the very high standard of beyond a reasonable doubt, then a prosecutor declines to prosecute. In fact, Mueller apparently did exactly this with the collusion, coordination, and conspiracy investigation, which Barr summarizes as finding that Mueller did not find enough evidence to establish those crimes. So why did Robert Mueller punt on the obstruction question, but not on the collusion and conspiracy question? Which brings me to the next point, point number 6. Why did William Barr weigh in on the obstruction issue? William Barr is a recent political appointee by President Trump. The point of the special counsel statute was for a neutral party to investigate the executive branch. If Robert Mueller found enough evidence to convict someone for obstruction of justice, the Barr letter appears to state that Robert Mueller did not decline to prosecute for obstruction of justice because there wasn't enough evidence, but because of some other legal issue. Then does that mean that Robert Mueller intended for William Barr to weigh in on the question? Or did Robert Mueller intend for Congress to answer this question? Was it intended to be teed up for Congress to make that decision? Declining to make a, quote, traditional prosecutorial decision is not necessarily inviting the political appointee, William Barr, to make that decision. And on top of that, Robert Mueller, as special counsel, has exclusive jurisdiction in this matter. Why did he decide not to move forward with the obstruction prosecution? We know that when Robert Mueller does not find enough evidence to prosecute, he makes a decision not to prosecute. But here, in the context of obstruction of justice, Robert Mueller is refusing to make any decision whatsoever. We will only know what that means when the full Mueller report is revealed. And on top of that, how is it possible that William Barr can make this decision in 48 hours when Robert Mueller couldn't make the decision in 2 years? And was William Barr even able to review all of the underlying evidence in this case? We don't even know how long the Mueller report itself actually is. Which brings me to point number 7. Whose legal conclusions are these, and are there other legal conclusions that we haven't seen yet? The Barr letter only purports to convey Mueller's top-line findings and does not include any of the underlying evidence or legal analysis that undergirds those findings. The Barr letter talks about the 2, quote, principal findings of the Mueller report, but does that mean that there are other legal findings that Mueller concluded that are not part of these top-line findings? And as to the legal conclusions that we have, we don't know whether Attorney General Barr concluded that the president did not obstruct justice as a factual matter, or that it wasn't legally possible for him to have obstructed justice. Again, going back to Barr's unsolicited 19-page memo, he argued a minority position that a president effectively cannot obstruct justice when it comes to using his Article 2 power. And Barr also argued that the obstruction of justice statutes don't apply to the president because they do not specifically mention the president. If Attorney General Barr imputed those minority legal positions onto Robert Mueller in the investigation, then it was effectively impossible as a logical matter for the president to have conducted obstruction of justice. Which brings me to point number 8. Why did Barr quote the portion of the Mueller report that states that the Mueller report does not exonerate the president? The Barr letter is potential partisan whitewashing. We don't know what's in the underlying report, and we don't know how accurate of a summary the Barr letter actually is. It's possible that Barr is intentionally setting the narrative before the full Mueller report comes out. But even still, why include this cherry-picked phrase that is actually detrimental to the president, stating that the Mueller report does not in fact exonerate the president? If a report or evidence doesn't exonerate someone from a crime and you're writing a summary about it, you don't have to include a sentence that says the report does not exonerate that person. You can just leave it at the fact that the crime was not established or that the decision was made not to prosecute. You don't have to go to the extra step and say that it doesn't exonerate that person. It seems like an odd inclusion in this very high-level summary of the Mueller report. Which takes me to point number 9, which may be the most baffling thing about the Barr letter and potentially the Mueller report itself, which is that there was a decision made not to prosecute for obstruction of justice, but that decision was made without interviewing the president. Was there an effort to actually interview the president? We know that under past precedent, under the Clinton versus Jones affair, and also the Starr investigation into President Clinton, that the president can be made to stand for an interview. Was an effort to get President Trump to stand for an interview made? And on top of that, why allow the president to offer written answers to written questions in lieu of an actual oral examination? Obstruction of justice requires proving that the defendant had a corrupt motive in conducting the acts that constitute the obstruction of justice. The best way to determine that is to interview the defendant. Now, potentially the defendant can take the Fifth Amendment, but here, given that the best evidence, one way or the other, is going to come from the president about his motivations in taking these different actions, why was the president not interviewed in this investigation? Now that the investigation is done, Attorney General Barr is going to have to read through thousands of pages of the Mueller report to determine what can be publicly released. He could really benefit from a speed reading class to get through the full Mueller report quickly, like Silvio Marisca's Skillshare class on speed reading, which could teach Barr to triple his reading speed in 7 days. Silvio's class could teach Barr how to read the Mueller report at 1,000 words per minute, and at the same time improve his reading comprehension and retention. At that rate, we might actually see the Mueller report before the next presidential election. Skillshare is an online learning community that has over 20,000 classes on everything like lifestyle, design, technology, business, you name it. The first 500 Legal Eagles will get 2 free months of Skillshare when you click on the link below. The free premium membership gives you unlimited access to must-know topics so you can improve your skills and learn new things. So click on the link, get 2 free months, and start learning to think like a lawyer today. It could even help you read the Mueller report and figure out why he refused to make the call on obstruction. Do you agree? Leave your objections in the comments, and check out my other real law reviews over here, where I will see you in court.